Brigade presents The Realty Debate, powered by Reliance Home Finance with Manisha Natarajan.
There's one more confusion in the abundant tax landscape of real estate. In a recent move, the Delhi High Court has held that service tax cannot be charged on under construction property, which includes builder flats, group housing flats, and builder floors. The primary reason cited for this is that there is no clear-cut mechanism for arriving at a value of service element involved in such transaction. Over the weekend, we've been receiving questions from viewers asking us where they stand on this issue of service tax and should they stop paying service tax or ask for refund from developers who they have already paid service tax to. So let's get clarity on this new twist in the tale. Joining me are Kapil Kumar Sharma, joint partner at Lakshmi Kumaran and Sridharan, also Rohit Raj Modi, Director Ashiana Homes Private Limited and Vice President Credai. Just to set the background on service tax, gentlemen, before I come to you, now what is service tax on sale of apartment? It's applicable on almost all services that a consumer avails, including buying an under construction property. And this is a tax unlike VAT, which is levied by state governments. Service tax is levied by the central government on the construction services offered by the developers to buyers. In the case of an under construction property, the developer is deemed to be the provider of construction services to the home buyer, and hence service tax is charged on the service portion, including in the cost of construction. Okay, it's not charged on the entire value of the property, but only on the extent of the service element involved. And this, I think, Kapil, was the entire basis of the High Court ruling, isn't it? So what is the service element involved when you're constructing an apartment? Now, the first question we've received is, should we then ask for a refund on our service tax? Kapil?
Now, talking about the refund may be with respect to asking from a developer may be a problem because developer has already collected that amount and deposited with the department. So, probably seeking refund from developer may not be the option. Rather, the judgment itself covers that part and it says that for the purpose of refund, you may directly apply with department and department is bound to give back that same along with the 6% interest to the SSC. So, therefore, pushing department or pushing the developer for the refund may not be a feasible option. Rather, you should cooperate, the developer should cooperate with the SSC insofar as giving the relevant document for payment of challan, evidencing them and helping probably all the buyers, flat buyers to file for a refund claim and assist them in best possible manner.
So these are basically at a certain date the cutoff is, right? Complete payments which have been completed and collected before 2012. Rohit Raj Modi, I'm just unable to understand. You know, every week we do a tax issue and we are banging our head against the wall. What's going on? I mean, so this new ruling, first of all, my first question to you is, have you ever considered the demand of service tax by the government on flats and apartments as in not a very valid tax?
Well, a very personal opinion on that is that, yes, I have always thought that this is not a valid tax because property is being governed under the Transfer of Property Act. Now, property, real estate, immovable property somehow has landed itself into a unique situation where it comes under the Transfer of Property Act, the entire consideration, which is the 100% amount that a buyer pays to a developer. A part of it gets taxed as VAT, which means we are saying that there are goods which are being handed over by one dealer to another, and then there is a service component to it. So whether this thing is a service or a goods or transfer of property, there has always been a bit of a quandary. So yes, you asked me, I do think that it is not a valid tax to begin with, but the fact of the matter is that it's a law of the land and everybody is abiding by that.
Kapil, do you think now the Delhi High Court has struck it down, what happens? It can go to Supreme Court and the government can challenge it. If the government fails to challenge it, does it become the law of the land?
No, we have to be very cautious with this because there are rulings of the other High Court as well on this particular point. Particular to this explanation, that is there 65105, that is the law of land till 1/7/2012. After that, the position of law has changed. Though in effect, if you see this law, it has remained same over a period of time. With respect to the applicability to the all India level or a quad India level, I would have to say that Punjab Haryana High Court has held that this levy is perfectly valid. Then in the case of Bombay High Court has again held that this levy is perfectly valid. Karnataka High Court in this respect of this particular explanation have held that this particular levy is valid. So it's only a Delhi High Court decision which stand today in favor of a SSE or a home buyer, so to say, that the levy is not constitutionally valid. But the three other High Court that I have just quoted are on this point, this levy is valid. So there is an abundant amount of confusion among the buyer as to which decision would apply to which jurisdiction per se. So speaking about...
So tell me, do you then agree with Rohit's point that what are you treating an apartment as? Goods and services under VAT, or then a service provided by developers and therefore charged at service tax? I mean, why have these multiplicity of taxes which are so confusing and creating so much of heartburn for the buyer?
The problem is that to break it down in very simple word, the law of land as of now dates very clearly, states that in under construction property there are three elements, namely the land on which the center does not have jurisdiction to levy tax. With respect to VAT, they say state has an authority to levy VAT. With respect to service tax, they say the center has the power to levy service tax. So basically,
everybody wants a bit of that real estate, isn't it?
Correct.
So Rohit, at the end of it, I mean, the center also wants its pie and the state also wants its pie. So, I mean, has CREDAI done any lobbying to make it easier? I know that they keep talking about what? There are 40 plus taxes on real estate, something like that?
CREDAI has for last several years spoken several times on this with the officials in the concerned ministries. But what happens in future, probably once GST is in place, GST would be able to iron out some of these duplicacies. But let me tell you that even there, how real estate will get treated is not very clear under GST also. But I want to step back and come to a point, Manisha, that you made, that everybody wants to have share of this pie. Interestingly, when a developer is being treated under the law now as a contractor to the buyer, if he is selling under construction property and collecting consideration from the buyer, and he's a contractor to the buyer, then why should stamp duty be levied on the 100% consideration? What that means is that a home buyer has basically hired the developer as a contractor, and that's why he's paying VAT on the built-up portion. In that case, on the full value, stamp duty should not be charged. When the stamp duty should be charged only on the value subtracting the construction value, only on the land component in that case. That would have a huge impact on the revenue of individual states.
I think you've really raised an important point, Kapil. That's a very valid question, isn't it? if you're actually treating the developer as a contractor and subjecting him to both VAT and service tax, then why are you not deducting that construction value and only having stamp duty on the land value?
The problem is in the fact that every jurisdiction or every act has a power. So the stamp duty levy is per se on the conveyance of a property. Now when you convey a property, there are two things which are getting conveyed to the buyer. What are they? They are the land, that is undivided share in the land of the unit or the flat. And secondly, the construction, the superstructure, because the ownership is getting transferred. For this specific reason, because conveyance is happening for both the thing, undivided share of land as well as the material portion that is forming the part of construction. For this reason, the stamp duty is on the entire value, and that's how the act has been framed. Perhaps the center has a jurisdiction to cut down that, or to cut down on the levy part, or to make provision to do away with this, or to provide a concession rate. Those are subject matter of state jurisdiction to do it or not.
Okay, the other contentious issue is the VAT itself. Haryana, look at the mess which is happening, and it's still not got resolved. I'm really fed up of bringing VAT again, but I have to, because now we've got Rohit and we've got Kapil here. It became applicable in Haryana in 2013, almost 3 years, and there's still no clear-cut method to calculate the amount payable as VAT. Developers are charging anywhere between 4.25 to 5.25% as VAT from buyers, and in the absence of clarity, some developers, and I would say the number is few, very few, are depositing the amount in the escrow amount as FD with a lien over it, so that they can adjust the required amount and refund the rest whenever the government clears the air on the computation. Kapil, you're the expert here. So there's also an amnesty scheme where the Haryana government has made an enabling provision to provide an amnesty scheme, but none has been notified as yet. What is going on? Why can't they just notify it? I mean, look at the number of buyers who are moaning and groaning. 3 to 5 to 6 lakhs is not a small amount that they've got slapped with.
There are two things to it. The amnesty is for a period prior to 1/4/2014.
Right.
The amnesty will bring relief not only to the buyers but to the developers also, because every time the time passes, the burden of interest, penalty and tax is going on increasing with the developer as well.
Absolutely.
So it is hitting the industry also. It's a two-way sword. It's hitting industry as well as the buyer.
Correct. Here
Because
I'm not even saying, except for the method in which some developers are collecting and what they're doing with the money, we don't know. But developers are equally pained with this.
Correct. The problem lies in the fact that in the absence of absolute clarity with respect to the provision and the amount that buyer needs to pay for a VAT, unless that thing takes place, unless that mechanism for computation of VAT per unit is being bring out by state with absolutely highest amount of clarity, the developer will always loom large in a dark room as to what should be the correct figure, because every question or every time he computes his tax liability, he arrives at a different number, because the cost keeps on changing, the demand keeps on changing. So there is the mechanism provided in law in today's date is not that robust that you can arrive at a final number which you have to pay to buyer.
How hard can it be to have clear policies? Is it really seems like an Einstein sort of a problem, Rohit? Is it that big a problem that you can't have clear-cut policies on deducting at VAT, arriving at a VAT?
Well, you see, there are essentially two methods. And Kapil would be able to expound much better than me on this, that you can go for an assessment where it's all the headache because there are no clear-cut understanding. As Kapil very rightly said, a real estate project goes on from 4 to 5 years time. The cost is literally a moving target. So on what basis you derive at, and you have to derive on the basis that the day the agreement is signed with a buyer, he or she is liable to pay VAT only thereafter on the value which is added thereafter. So if I'm selling on a daily basis, say one apartment, I have to really come to a very, very fine mechanics to come to my costing of a daily basis, that what cost has been incurred today and what's the balance cost, which is a very, very tedious job. Now, having said that, many states have come out with composition scheme where they've offered the developer to charge a flat 1%, 0.6% on the sale value, to pay the VAT at 1% or 0.6%. So some states have allowed the developer to charge that to the customer and others haven't. So there are differences in policies. If you look at one of the earliest ones was in Maharashtra, and Maharashtra had come out with a very clear policy long time back that 1% of the sale value will be collected and deposited as VAT, and that has to be done at the time of the registration of the at the conveyance of the property. We have seen various versions. Gujarat charges 0.6%.
Okay, fair enough. So Kapil, wouldn't that be an easier one to do?
Is coming in, yeah.
Wouldn't that be an easier one to do? Just have a percentage between anywhere ranging between 0.5 and 1, come to a conclusion on that. And also my last question to you, would VAT get subsumed with the GST?
There are two questions. First one, with respect to Haryana also, there is a scheme of composition available in today's date, right, that allows you to compute tax on the 1% of the sale value of the immovable property and pay it to tax. The only hitch in that is there are certain conditions which you have to bound to follow that. The major issue is that you are not supposed to collect that amount from the buyer. So that is the only issue, that the developer has to back calculate the computation, arrive at 1% on top of some other amount and then pay from his own pocket. So he is not actually allowed to pass on the amount of tax that he has paid to the buyer.
Okay, before we go on to the next question, Rohit, that it is available and the developer is not supposed to pass it on, then why are they passing it on?
No, you see, the composition scheme which has come only a few months back. So now the developers who have opted for composition scheme, they are not really passing it on to the customers. What is happening, what you referred to was because of the fear of the past dues, since the amnesty scheme has not been notified, that how will one pay the past dues. The problem is all related to the past dues. If the government can come with a clarification and now notify the amnesty scheme, you'll find 95% of this problem getting out of Haryana market.
All right, fair enough.
The whole issue is about that amnesty scheme. And also, Manisha, I would like to, Manisha, I'll just take 1 minute. VAT is always on value addition by the trader. So why should real estate developer not be allowed to pass that on when every other product passes on the VAT to its buyer?
It's a big question. Kapil,
No,
even though
I
the
think
law does.
the only law has also.
But any which way, the developers are going to build it in the product. It's
Correct,
not as if anybody is going to, pay from their product, from their pocket. Pardon me. Does VAT go once you have GST?
Yes.
It
VAT
goes?
is, yes.
It goes. Okay.
VAT.
So, all that the Haryana government right now needs to do is to notify that amnesty scheme and put thousands of buyers out of their misery. And developers are facing the flack of it here. I'm taking totally the developers' side. They're facing the flack of it because we get buyer letters blaming the developer, saying, ये हमसे और पैसे मांग रहा है, ये हमसे और पैसे मांग रहा है, and why should we be paying? So really the ball is in the Haryana government's court. Gentlemen, thank you very much for joining me. That's it from me on the Realty Debate, the premier platform to ring in and ring out the big issues in real estate. So don't forget to tune in every Thursday, 7 p.m. and 11 p.m. is when we come to you. Your feedback is always welcome. You can reach us at property@ndtv.com or just follow our Twitter handle or Facebook account. Always happy to get your suggestions. Goodbye.